We're going to discuss insurance appraisal here today, what it is, how it works so that you can make a well-informed decision regarding how to proceed forward. Don't make the mistake of confusing insurance appraisal with real estate appraisal, which determines the sales value of a property. Rather, in insurance appraisal, we determine the amount of your loss, the dollar amount that you will be out of pocket to restore the property to its pre-loss condition due to the event. My name is Steve Patrick, and I'm an insurance appraiser. I even owned my own claims adjuster licensing and training company. I'm one of the founders of Level the Playing Field, helping consumers get a fair shake for their legitimate property claims. I've done almost 2,000 insurance appraisals over the past 25 years, and I teach the subject nationally. So if you have a property claim and your claims adjuster refuses to be reasonable, insurance appraisal may be an excellent choice for you for alternative dispute resolution. Perhaps your adjuster overlooked legitimate damage. Maybe they're not a construction expert, and their method and means of repair is not based upon construction industry standards or compliance with OSHA or even applicable building codes. Perhaps they're missing legitimate line items on their estimate, or maybe they've created a correct, thorough, and comprehensive scope of work, but are simply lowballing a fair price. If you're having a dispute over the amount of your loss, how much you're going to be out of pocket because of this event, then appraisal may be an excellent choice for you. The appraisal process is well established, helping consumers obtain righteous outcomes for over 100 years. The process is based upon the appraisal clause tucked away deep in the mired language of your property policy. Here's the wording from a standardized property policy. Your wording may slightly differ for this, yet substantially it'll have the same effect. In the case the insured and this company shall fail to agree as to the actual cash value or the amount of loss, then on the written demand of either, each shall select a competent and disinterested appraiser and notify the other of the appraiser selected within 20 days of the demand. The appraiser shall first select a competent and disinterested umpire, and failing for 15 days to agree upon such an umpire, then, on request of the insured or this company, such umpire shall be selected by a judge of a court of record in the state in which the property covered is located. The appraiser shall then appraise the loss, stating separately actual cash value and loss to each item, and failing to agree, then submit their differences only to the umpire. An award in writing so itemized of any two when filed with this company shall determine the amount of the actual cash value and loss. Each appraiser shall be paid by the party selecting him, and the expense of the appraisal and the umpire shall be paid by the parties equally. Here's how it works in the real world. You hire an appraiser, me, and your insurance company hires their appraiser. The first thing we two appraisers do is name an umpire. He's the tiebreaker. This is the guy or gal that steps in if the two appraisers come to an impasse, and this individual helps them settle the matter. About 50% of the time, the insurance company names a reasonable appraiser, and the umpire is never necessary. The two of us simply settle the matter. Conversely, about 50% of the time, they name someone unreasonable, and the umpire will need to be involved to bring the process to a successful and timely conclusion. Once any two of the three on the panel agree on the amount of your loss, that sets the amount of the loss, and typically a check for the difference is mailed out within days. The process is now concluded. There are 4 basic benefits that make insurance appraisal make sense for most folks. Benefit number 1, circumvention. Have you ever felt like dealing with your insurance company is like beating your head against the wall? With appraisal, you're circumventing the claims department completely. You're essentially going around the brick wall that's been obstructing you. Once you evoke the appraisal process, which we'll teach you how to do, your insurance company has 20 days contractually to name their appraiser, notify you and me of their appraiser's identity and contact information, so the process can begin. Once they receive notification that you're demanding appraisal, the claims department must stop adjusting the claim and hand it over to their named appraiser. The claim is now out of the obstructionist's hand, the claims department. Your claim is now in appraisal, and it's an entirely different game, a level playing field. Benefit number 2, independence. Both appraisers on the appraisal panel must be independent and disinterested. What does that mean? Black's Law Dictionary defines independent as not dependent, not subject to control, restriction, modification, or limitation from a given outside source. This simply means that neither party can tell their independent appraiser what to say, think, or do. The appraisers must remain unbiased and use their expertise to determine the amount of your loss, including all legitimate damage, a reasonable means and method of repair using standard construction standards, complying with the building code and OSHA, at a fair price, regardless of what the claims department thinks. Your insurance company cannot direct their appraiser, nor can you. Benefit number 3, reasonable cost. We work by the hour rather than a percentage of your claim. Therefore, our fees are more affordable than attorneys or public adjusting fees. At the time of this recording, June 2026, we charge $250 an hour for residential claims and $350 an hour for commercial claims, plus reasonable expenses. For example, travel time and costs incurred. PAs charge a percentage of your entire claim, and attorneys do as well. Benefit number 4, timely. Appraisal is typically quite a bit faster than hiring a lawyer or public adjuster. On average, appraisal takes about 2 to 4 months to finalize when an umpire is not needed, and an extra month when one is. These are averages. Some take more, some take less. Obviously, complex and commercial losses take more time and cost more money. What kind of expectation should you have? If your claim is legitimate, that means you have legitimate damage and your contractor's means and method of repair is reasonably necessary, then you should reasonably expect to receive about 65 to 85% of the replacement cost spread, the amount in dispute. 75% is the average sweet spot. So if you have a $100,000 dispute, then you could reasonably expect to get around $65,000 to $85,000 of the $100,000 in dispute. As an example, let's say that your contractor's estimate is $150,000 and your insurance company's offer to settle the claim is $50,000. This leaves $100,000 of this amount remaining in dispute. On average, appraisal should get you about $65,000 to $85,000 of the $100,000 in dispute, around 75% or so. Sometimes more, sometimes less. We do not win every appraisal, but we do about 95% of the time. I define a win as you receiving enough claims proceeds to do the work of restoring your property after you've come out of pocket paying your contractor their deductible. In insurance claims lingo, you have now been indemnified. You've been made whole. Realize that if your insurance company has agreed to pay you anything, even $1 for your claim, then they have extended coverage for your claim, and all repair scope and pricing are appraisable. Even the amount that they've depreciated your claim is appraisable. If your insurance company's scope of work is not in dispute, but they're lowballing the price, you can still demand appraisal for pricing only, and there will be no need for a site visit. I won't even have to go out there. We refer to this as a desk appraisal. We handle it over the phone and by email. It's much quicker and costs less money. Realize the appraisal panel has no authority to determine coverage or even discuss it. What is coverage? It's who owes for what. We only determine the amount of your loss, regardless of who owes for what. How much are you going to have to be out of pocket due to this event? So, how do you start the process? Reach out to me. Text me your name and email address to 214-244-2639. And then I'll email you our appraisal packet that explains the entire process for you, step by step, along with the paperwork. Once you have completed the agreement, officially hiring us, and paid a reasonable retainer, the next step is for you to invoke the appraisal process in writing. Our appraisal package includes a sample appraisal demand letter. We aren't lawyers, so use this as an example, putting your demand letter in your own words. We'll provide the sample demand letter for educational purposes only. Once you have your demand letter ready to send, email it to both your insurance agent and your most recent claims adjuster assigned to your claim. Demand that they reply to your email right away so they cannot say that they never received it. You might be surprised how often they try that. If you have any questions regarding the process, do not hesitate to text me 214-244-2639 and we'll set up a time to visit on the phone. A quick disclaimer, I am not an attorney and we are not a law firm. Nothing contained or provided here is intended nor should be construed by you as legal advice. Always contact a legal attorney if you need any legal advice.